Welcome to Looking at Legal Stuff. Today we have 12 hearings in a case with a couple where Mom has motioned the court to move several hours away for a new job opportunity that will allow her to better support their 5 children. She had been offering to transport the children back for Dad's visitation until a recent incident that occurred on his weekend where Dad was both drinking around the children as well as accidentally leaving their 5 children home alone. Dad claims that it was just a miscommunication with his sister, who he thought was at home babysitting them while he went to work, and he would have left work immediately if he knew. He also says he really needs a reduction in child support for his 5 children because he will never be able to afford his own place for visitation if he has to keep paying so much in support. The guardian ad litem recommends suspending his visitation until Dad have a substance abuse evaluation. Dad drags his feet and has a million excuses for why it's taking him so long to get it done, and seems more concerned about reducing his child support during the hearings than he does increasing his visitation. Let's see what the judge thinks.
Alyssa Gutierrez and Francisco Gutierrez. Either of them here. Alyssa Gutierrez and Francisco Gutierrez.
Your Honor, I'm Keith Lawrence, the guardian ad litem in the matter.
Francisco, you want to unmute yourself? Well, Mr. Lawrence, have you been in touch with the parties?
Yes, I have, Your Honor. I had some trouble reaching Mr. Gutierrez. I tried for 3 months to try to get a hold of him through phone calls and email messages. And I finally was able to reach him and had a Zoom meeting with him on May the 17th of this year. I did make a home visit and spoke with Alyssa and the children on February the 1st of 2023. She was having problems coming up with the money to pay my fee, but that has since been resolved. And I have now been able to have a meeting with Mr. Gutierrez, goes by his middle name, Julian, and I met with him. And at that meeting on May 17th, he indicated that Alyssa has since filed a motion to move to Ellensburg. And I've had brief contact with Alyssa about that. Apparently there's some friends or family that live in the Ellensburg area. And I haven't had a chance to explore that fully at this point. So I need another appointment with Ms. Gutierrez. And then I need to go back to Mr. Gutierrez and present to him what her plan is. She's offering to transport the children for visits from Ellensburg, and he lives currently in Vancouver. So at this point, I need some extra time to finish off my report.
All right, thank you. Ms. Gutierrez, can you hear me? Can you unmute yourself?
Yes, I can hear you.
All right, thank you. You brought a motion to show cause regarding child support that's not paid and Mr. Gutierrez not working with the GAL. Do you want to address that motion?
Yeah, so I had done that motion before he decided to finally reach out and work with the guardian ad litem. So that part has been resolved. He is now working with the guardian ad litem. And I've been working with DCS trying to get the child support situated. He's currently caught up except for last month. I just wanted to see if I could possibly get an order to have child support go through DCS from here on out. He needs to work with them because all I get from him is threats on, if you don't do this for me, I'm not paying child support. And that should not be the case. I shouldn't have to abide by his orders to receive child support for his children.
All right. Mr. Gutierrez, can you hear me?
Yes, I can hear you.
All right. So I'm glad you're working with Mr. Lawrence. And it sounds like Ms. Gutierrez wants the State Child Support Division to handle child support. I don't know that you have a choice in that matter, but I'll let you respond if you want.
Thank you.
Let's
This is Casey Looney on behalf of the State Department of Child Support. And we will be filing a notice of appearance on this case because Ms. Gutierrez had requested a modification for child support that had not yet been addressed by the court. But we will be entering a notice of appearance to work with the case to figure out how to set child support on this one.
Okay, well, I guess that answers the question, Mr. Gutierrez, that the state will be involved. So that leaves the motion to relocate. Yesterday, I got an ex parte motion to allow an immediate relocation. I held that over to today because this case was coming up. And what I would like to do is put this over 1 week. That's before the move time stated by Ms. Gutierrez, which is June 12th. I'd like to put this over to, I think it's June 8th, not maybe June 7th, next week, just to address the request to move. I would like you both to get a hold of Mr. Lawrence to discuss your concerns and your issues with him. He has been very helpful to me in the past in sorting out parties that would like to move with the children and determining how to go about that. So I would like you to get a hold of him and deal with that. For today, I'm going to deny the motion for contempt since it looks like the state is involved with child support and Mr. Gutierrez is now working with Mr. Lawrence. And then we'll put this over to June 7th to deal with the motion to relocate. All right?
Sounds good. Thank you.
All right. All right. Thank you. All right. We're at Alyssa Gutierrez and Francisco Gutierrez. I think they're both here.
I'm here.
All right.
I'm here.
Mr. Gutierrez here. There was a report by Mr. Lawrence. Did both of you have a chance to see that?
Yes.
Okay. Why don't we hear from Mr. Lawrence first, and then I'll give the parties a chance to respond, and then we'll have to make some decisions. Go ahead, Mr. Lawrence.
Your Honor, as the court recalls, last week, I guess it was,
It was.
The court asked me to investigate the requested move on the part of Alyssa to Ellensburg and to give the court guidance for your decision today. I did meet with Alyssa, and I also met with Francisco, who goes by Julian. And what I discovered is that Alyssa actually grew up in Ellensburg, and she has a lot of family there. And her job here with FedEx was requiring her to spend more and more time away from the kids, and wanted her to undergo a 2 to 3 week training where she would have been out of town. And she didn't want to do that. And so she sought a new job and found a dental assistant apprenticeship with Mountain View Dental in Ellensburg. And she starts out at $20 an hour. And after 120 days of her apprenticeship, she would earn her certificate, and then her rate of pay would go up to $26 per hour. She is rented a home in Ellensburg that is 1 block from the elementary school and just a couple of minutes from the middle school. So the kids, the home is close to the school for the kids. She would not be spending as much time away from the children. She'd be working a 10-hour per day schedule. And so she has volunteered that she would be willing to maintain the visitation with Julian and the kids by transporting the children to and from Ellensburg to Vancouver. And so he would lose no time with the children. She would also sell the family home, which she was awarded during the original divorce. Julian, I had a chance to speak to him. His concern is that he is now living with his sister in Vancouver, and with child support, he doesn't have the funds to actually pay child support and find a new home of his own. So he was concerned that if she moves, he would not have the ability to maybe relocate to Longview and then be able to have a 50-50 arrangement with the children and potentially reduce his child support down to zero. And so this move of Alyssa's would destroy that plan. Alyssa indicated that when they first separated that she had researched rooms for rent for him in the Longview area, but he rejected that and decided to go ahead and move down closer to his work at the post office. He's near the Portland airport. So we're kind of in this standoff situation. My impression from talking to Julian was not so much that he was concerned the kids are going to be moved a further distance away from him, but more that he would not be able to then get a 50-50 arrangement and be able to reduce his child support. In addition to that, my recommendation, as the court has seen in my report, is that Alyssa be allowed to move to Ellensburg with the children, and that the visitation remain status quo, at least for now. And the other part of that is Alyssa sent me an email shortly after the Memorial Day holiday, indicating that there had been a major issue with the visit, that the oldest child, Carson, had called on Saturday morning, or Saturday sometime during the day. I assumed it was morning, but it could have been afternoon, that the children awoke and Francisco wasn't there. And they didn't know that he was going to go to work, and they didn't know where he was. Carson indicated to his mother that about 2:00 he returned from work, but in Carson's interpretation, he thought his father was drunk. Then on Sunday morning, the children again awoke that Francisco was not there. And also the sister was not there as well. And the children were left alone. And so Alyssa called the Clark County Sheriff's Office to do a welfare check. And I spoke to Julian about this, and he provided me with copies of his work schedule, which I included in my report, that he apparently was scheduled to work both Saturday and Sunday. However, he didn't communicate that well. Alyssa thought that he was not working on Saturday. She was aware he might be working Sunday. Julian's sister was aware that he was working Saturday, but not aware that he was working Sunday. And his sister's husband had a soccer match. And so she went to watch him play and left the kids without checking Julian's room where the kids were sleeping. And so the kids woke up and nobody was in the home other than them. And I asked his sister about whether or not he came home drunk on Saturday. And she said, no, she didn't think so. But she did indicate that he had 3 beers after he got home from work. And his sister indicated that she guesstimated that the children on Sunday were left at home alone for about an hour and a half. Now, understand that Stella, the smallest child, the older child, Carson, would have to change her diapers. And also she has food allergies. And if she ate something she shouldn't have, he would have had to administer her EpiPen. And he was not prepared to do that. So at this point, the primary allegations surrounding the separation which led to the divorce, and now the issues with the visitation, is Julian's drinking. He apparently was in the Kaiser Permanente addictions medicine program. He was in outpatient treatment, but Alyssa provided me with a copy of a letter from that program indicating that he had failed to show up, and they were giving him a few days to respond or they were going to discharge him, which apparently they did. I think at this point, there's enough smoke here that I am real concerned about Julian getting a substance abuse evaluation that includes Alyssa and my input, so that the evaluator gets a full rounded picture of what we're dealing with. Once that happens, well, let me back up. I think it may be in the best interest of the kids to suspend visits at this point, pending this evaluation. And if he decides to then enroll in any treatment recommendations, then we start meeting out more and more time for Julian with the children. And as long as he is in compliance with these treatment obligations, then he gets, again, more and more visitation time with the children. But under no circumstance should he ever be consuming alcohol, either just prior to or during any visits with the children. And that would conclude my report, Your Honor.
All right, thank you. Let me hear from Ms. Gutierrez, and then I'll go to Mr. Gutierrez.
Hi. Yeah, I agree with everything that Keith has said. That's honestly been all I've wanted since the divorce. When I originally filed the parenting plan, he was trying to go to an outpatient treatment. So I figured, I'd give him the chance and benefit of the doubt. I thought that he was going to follow through with his treatment and be able to be a better father for the kids. He tried it twice. He decided to leave both times. The treatment center tried to reach out to him and get him to come back, and he refused to go back. So at this point, it is a concern that the kids are around that, and the one person that I trusted to kind of be a supervisor was his sister, and it seems that she's not set to do that, being she can't tell him, not to drink around the kids. He won't listen to her. And at this point, I just want him to get treatment and be better for the kids. I have no problem if, they decide to suspend his visitation for now. I do think that I can do like video calls and phone calls just to keep that relationship between them, because I know it's very important. The kids are a little standoffish, but I will continue to keep in contact so that he can at least have conversations with them. I think the drug and alcohol evaluation would be beneficial so that they can actually see what we're dealing with. And hopefully they will decide to do like some kind of test to prove his consumption. And then my other concern, like my daughter does have really bad allergies. She has to have an EpiPen, but my other concern is my 5-year-old. He does have a heart condition, so he has to be, with an adult all the time. His blood pressure can go up. He has bad asthma, so he has to have an inhaler as well. So them being left unattended is not acceptable. I feel that he needs to have adequate childcare if he's going to have visitation.
All right, thank you. Mr. Gutierrez?
Yes.
You can respond to anything that Mr. Lawrence or Ms. Gutierrez said if you'd like to.
I don't see the point of doing any treatment. I don't feel like I need to. I mean, if I have to, I do it. I don't have a drug problem. I think having a beer or two here and there, I don't see that as a big issue. They're just trying to paint a big image of me having like this big alcohol problem, which I don't have. But I mean, I'm willing to do anything as long as I get my time with the kids.
Let me start with the request for an immediate order that Ms. Gutierrez be able to move with the children to, I believe it's Ellensburg. And Mr. Lawrence laid out a number of criteria based on RCW 2609520. These criteria are essentially a balancing test. So not one is controlling, but the court is to look at all of these factors and determine whether on balance the move should be allowed. I'm going to adopt the evaluation by Mr. Lawrence on his factors 1 through 11. And I'm going to find that on balance, the move to Ellensburg should be allowed. And so Ms. Gutierrez can move the children there and begin her new job. The second issue is the alleged alcohol use. I find the evidence that Mr. Gutierrez came home drunk is not sufficient for me to base any decision on. But there are two other factors that do cause the court concern. It's apparently undisputed that when he came home on, I believe it was Saturday, he had 3 beers while he was watching the children. But sir,
can I say something about that?
Well, okay, go ahead. Your sister said you had 3 beers, so go ahead. What do you want to say?
That was late in the evening. That wasn't right after I got here. I got here around 2 o'clock, maybe 1:30, and I picked them up. I took them to the park. I took them out to eat and came back. We all showered. We all, got comfortable and stuff like that. That wasn't during the day. That was like later in that evening. That was like right before bed. We were just chilling. We were just playing video games. And yes. That was...
Your children were with you at that time, right?
Yes. I mean, I have pictures of them playing at the park and stuff like, and out to eat and stuff. So that was not right when I got here. I picked them up and I took them out. And if 2-3 beers I had, that was in the evening. That was late, not super late at night, but that was after 9 o'clock or 8 o'clock, something like that.
All right, thank you. What's more concerning is that it's also well, it's not disputed that the children were left alone at least an hour and a half. That's the sister's estimate. Sir, I've listened to everybody comment on all of this, so I'm going through my decision. Okay. So apparently 2 of the children have health concerns. To allow the children to be alone for an hour and a half is just not acceptable. So
Your Honor,
there does need to be some objective inquiry into whether there is a substance abuse issue.
if about that day, if I knew my sister had left or was going to leave, I would have left work right away. I didn't find out until like 45 minutes later or something like that she was not here. So that's when I left work and rushed over here because I had plans for them. But if I knew my sister left, if she would have told me something or said something to me, I would have been here sooner.
Well, there appears to be at least a breakdown in communication between you and your sister over this issue, because leaving 5 children, many of them very young and with health issues alone, is, again, not acceptable. So,
I mean, she's done the same. My oldest son talked to me about it. She's done the same thing to them, including with her boyfriend's children as well.
All right, Mr. Gutierrez, I need you to listen to the rest of this without comment. If you start commenting, I'm going to mute you because I need to let you know what we're going to do. I am going to take Mr. Lawrence's suggestion at this point, and I'm going to suspend visitation. I want Mr. Gutierrez to obtain a drug and alcohol evaluation, and that will be with collateral input from Ms. Gutierrez and Mr. Lawrence. I want the results of that to be filed with the court. If treatment is recommended, then Mr. Gutierrez will need to follow it. If Mr. Gutierrez is right and he has no problem, then after the evaluation, no treatment should be recommended, and we'll go from there. But the court needs, at this point, objective evidence that there's no problem. When, well, we'll look at the results of that and hopefully as quickly as possible begin visits again. Ms. Gutierrez has offered to transport the children to where Mr. Gutierrez is, and so that will be part of the order whenever we get to that point. Prior to that, I'm going to allow video and telephone visits as frequently as possible between the children and Mr. Gutierrez. When the drug and alcohol evaluation is done, then that needs to be provided to Ms. Gutierrez, Mr. Lawrence, and also filed with the court. Okay. I'm going to sign the immediate order allowing the move. And I think we should set a review hearing to see if that evaluation is done. We should probably go out to July 12th on that. And that would be for the purpose of checking in on the evaluation. If it's done sooner and Mr. Gutierrez wants to get this to court sooner than that, you're free to file a notice of hearing and send it to everyone, and we can address this soon. Okay. All right. That's it for today. Thank you.
Thank you, Your Honor.
I'm here.
Can you hear me? Yes, I can hear you, Ben.
Okay, there we go.
Okay. So this is case 223-0009608. By my notes, and again, this is a case I recognize I am stepping into after many things have occurred. But the last item I see is Commissioner Nelson suspended visitation for Mr. Gutierrez and ordered that you obtain a drug and alcohol evaluation. We were going to wait for some collateral input from Mr. Lawrence on that, and then we would discuss future visitation. So first, I guess, Mr. Lawrence, similar to the last case, I'll turn it over to you to fill in any gaps I may be missing, or let me know if that's your understanding of why we're here today as well.
Yes, that's correct, Your Honor. To kind of brief report, on Memorial Day weekend, Mr. Gutierrez had the children on a visit.
Hold on one, just sorry to interrupt you, Mr. Lawrence. Mr. Gutierrez, there's a lot of background noise happening on your end. Can you just mute until I take testimony from you?
Okay.
And Ms. Gutierrez, I'll have you do the same. Just keep your camera on, but just mute it until we have you testify.
Okay.
Okay, go ahead, Mr. Lawrence.
There was some miscommunication. Mr. Gutierrez lives with his sister in Vancouver, and they share an apartment together, and the kids came down for a visit, and Alyssa was aware that Mr. Gutierrez goes by Julian, his middle name. She was aware that Julian was going to be working some during that Memorial Day weekend, but she didn't know the exact days. And the same thing with his sister, knew that he was going to be working, but again, didn't know all of the days he was going to be working. So what happened was the kids woke up on Saturday and Mr. Gutierrez wasn't there. And so they were concerned as to where he went. And he came back in the afternoon, and the one child, Carson, indicated that he thought that his dad was drunk. And Mr. Gutierrez's sister indicated that no, she didn't think he was drunk when he returned from work, but that he did have 2 or 3 beers after he got home. And again, Mr. Gutierrez was gone on Sunday, and his sister went to watch her husband play soccer. And so the kids got up and there was nobody there. And Carson called his mother, and Ms. Gutierrez then requested a welfare check from the police. And ultimately it all got straightened out, but there was allegations of drinking. There was allegations of leaving the kids unattended due to poor communication. And the reason that we're even here, why the divorce was based on an incident in which Mr. Gutierrez became intoxicated on a New Year's Eve. Anyway, Ms. Gutierrez then was able to find a position in Ellensburg, Washington, as an apprentice dental assistant. And at the last hearing, we were addressing whether that move should occur. And we also then addressed the visitation by Mr. Gutierrez, and Ms. Gutierrez has wanted him to undergo a substance abuse evaluation, which he was not obtaining. So I had recommended that the visitation be suspended until he obtains this evaluation with Alyssa and my input. I checked Odyssey yesterday. I did not see any evaluations filed in Odyssey. I also did not receive any kind of a request from any evaluation agency requesting my input on his evaluation. So my assumption is that he has not done that yet.
Okay. Thank you. Mr. Gutierrez, let me, on that specific point, if you want to unmute, have you been able to comply with the commissioner's order to obtain a drug and alcohol evaluation yet?
No, I have not, because I don't know where to go or number to call. I honestly, I don't know exactly what that is. All I did was I did do a drug test, and I screenshot pictures of the results, and I emailed it to Mr. Lawrence, and that's all I've done. But as far as the evaluation, I haven't done it, because I mean, if I could have some sort of a paper of instructions or something, a number to call so I can go do it, or maybe I get more time to get on it, I have no problem doing it.
Yeah, and Mr. Lawrence, I don't know if part of your resources include facilities that do these kind of services where Mr. Gutierrez is located?
I can find out, Your Honor, and make that information available to him.
Okay, let's do that. And my thought is we'll set a review date. Now, typically I would just do a 30-day review date so that we can, address visitation sooner than later. Mr. Gutierrez, I'll somewhat leave it up to you. I know the first step is that you'll have to call and get the appointment. I do know that getting the appointments can take some time. I doubt that you'll get in and have a report within 30 days. But I'm happy to do a 30-day review date if that's the party's request. Otherwise, I would propose 60 days, which I think is more realistic. What would be the party's preference on a return date? Mr. Gutierrez, since it's your visitation kind of on the line here, are you comfortable with a 60-day review date to get that done and come back to court?
I could do 30 days. I could do 60 days. It doesn't matter.
Okay. Well, then maybe we'll split the difference and do about 45 days. So that would put us at 30. Let's look at Wednesday, September 13 at 9 a.m. Will that work for the parties?
Sure, yes.
Okay. Mr. Lawrence, does that work for you, since we'll be looking for your input again?
Yes, Your Honor.
Okay. And Alyssa, does that work for you?
Yes.
Okay. And I apologize, Ms. Gutierrez, I didn't come to you for any input. Is there anything else you want the court to know for today's purposes?
No, I think that he's capable of getting it done within 30 days. I reached out to Kaiser. We both still have the same health plan, and they got back to me and told me that his drug and alcohol counselor that he had tried to see before would be willing to do the assessment. He just has to call.
Okay. And what I'll say is, if both parties want this matter heard sooner than September 13th, let's say the report does come back and you want me to take a look at it to review any modifications to visitation on, if the case is truly ready for me to review sooner, you can certainly note it on earlier than September 13th.
Perfect.
Okay. Otherwise, I'll see the parties back on September 13th and we'll address the review of the evaluation, any input from Mr. Lawrence, and talk about future visitation schedules. Okay.
Thank you.
Thank you. You're both free to log out. Let me go ahead and call Elisa Gutierrez and Francisco Gutierrez. I believe we have Mr. Lawrence waiting on that case. This is 223-000-9608. Good morning, Mr. Lawrence.
Morning.
Let's see. Do we have Elisa Gutierrez? We have Francisco Gutierrez, I see. Mr. Gutierrez, are you able to unmute?
I think so. Can you hear me?
Sorry, I was taking a sip of my coffee. I can hear you, sir. So we do not appear to have the petitioner present. I'm just checking our waiting room. I don't see anyone in there. When I reviewed this file, I was looking for the evaluations to come in. I don't see that, so I'm not sure what we would do today anyway, but Mr. Lawrence, any input that you have?
The court had asked me to assist Mr. Gutierrez in finding a provider. He has Kaiser insurance through his employment. He had formerly been in outpatient drug and alcohol treatment through Kaiser. And so he should know how to go ahead and sign up again. Mr. Gutierrez did try to reach me about a month ago. He left a voicemail and an email. I responded to him through a voicemail and an email, indicating a couple of dates that I would be available to speak with him. And I heard nothing back. So that's where we're at, Your Honor.
Okay. And I don't have the petitioner here, so in all likelihood, we'll simply be setting a new date. But Mr. Gutierrez, have you started the evaluation process?
Yeah, I did. I guess I need to get in touch with the counselor I spoke to, because she was supposed to send a mail to Mr. Lawrence and also to Alisa.
Okay. Where are you engaged in? Where did you do the evaluation?
I did it over the phone through my health insurance, the Kaiser.
Sir, I can't hear you. You're going to have to speak up.
Give me 1 second.
Okay.
I did it through Kaiser, through my health insurance.
Okay. And are they recommending treatment? Are you engaged in treatment?
No.
Okay.
She even had me do the very next day after we spoke, she had me do a drug test, which I did. And that was supposed to be part of the paperwork that it should have been mailed to Lawrence and Alisa as well.
Yeah. So here's my thought, especially since Ms. Gutierrez isn't here. Let's do that over. And what I want you to do, Mr. Gutierrez, is make sure, rather than, I'll tell you, sometimes with Kaiser, you can't rely on them sending the documents out. You have to actually go get them. And then you yourself would get them to Mr. Lawrence and or the court, filing them under seal. So I'm going to give you a new date. I want to have that evaluation to review at the next date. I want Ms. Gutierrez to be here for that date. What date do you want, Mr. Gutierrez? You think that you could go get the reports, get it to the parties, get it to the court, and come back here?
I can work on that today. I don't really have a set date. I mean, you can give me date, whatever day you like.
Well, I'm guessing you want it sooner than later, because that determines whether we can reinstitute visitation for you. So I assume you want it sooner than later.
Yeah.
Okay. So I could offer you Wednesday, the 27th, which is in 2 weeks, or we could go 3 weeks out to Wednesday, the 4th.
No, Wednesday, the 27th should work.
Okay. Mr. Lawrence, does that date work for you?
The date works for me, Your Honor. The question is whether or not, if we get the documentation from Julian for Kaiser to provide input, how long it's going to take for them to actually incorporate our information with their findings. I guess I would suggest that we move it out to 3 week date to give us a little more time.
Okay. I think that makes a lot of reasonable sense. So let's go ahead and set this to October 4. So 3 weeks out at 9 a.m. The hope there, Mr. Gutierrez, is that we won't have to do any further set outs, because that'll give all the parties and experts in the case time to get their stuff together, get it to Mr. Lawrence to make a recommendation to the court. Also, I will need to have Ms. Gutierrez present on that date, so we'll have to get notice of this hearing out to her. Okay? Okay. Anything else on this matter?
Oh, I just like to say something. My income has changed. My income has changed to where basically I have no income. Is there any way I could get that fixed?
So I can't give you legal advice, but I can say, are you talking about child support payments?
Yeah.
Okay. I can't give you legal advice. What I can recommend that you do if you have a question about whether child support can be modified is to have you reach out to either a family law attorney or a legal aid clinic that might be able to provide you free or low cost advice on that sort of issue.
Okay.
Okay.
All right.
All right. Thank you for your question, and you are free to log off. Mr. Lawrence, anything further?
No, Your Honor.
Okay. Thank you for your time.
Thank you.
Mr. Lawrence, I have you on the Gutierrez matter. We'll go ahead and take that. This is 223-000-9608. Do I have Elise? Is it Elisa or Alyssa?
It's Elisa.
Elisa Gutierrez. And do I have Francisco Gutierrez?
Yeah, I'm here.
Okay. So I have you both on for an adequate cause motion and a review hearing. So let me just get into this file. And then Ms. Looney, I see you're also present on this case.
Yes, Your Honor. We only discovered that this case was on for adequate cause, as well as the motion to adjust child support on Monday when this case appeared on the docket. We were not served with anything. So at this time, the state is requesting a set over as to the child support portion to November 1st.
And I think that makes sense. I have some other concerns regarding the adequate cause motion, but based on that request, I would be inclined to give the state additional time to review this matter, to give input to the court. Mr. Lawrence, any input from you on that issue?
None on the child support, Your Honor.
Okay. Well, yeah, well, let's take that one first, and then I'll come back to the review portion of this case. So Ms. Gutierrez, any objection?
No, I don't have any objection to that.
Have you been served the adequate cause motion?
So I was served, but I really didn't understand it because like all of his paperwork says that I'm the petitioner and I'm not the one petitioning.
Yeah, understood. Mr. Gutierrez.
Yeah.
So I think as you're hearing, you have filed a motion for adequate cause to adjust child support. The state has to be involved in that process, and they only recently learned of your request. So they are requesting a set over to November 1st. I am inclined to grant that. Do you have any objection?
May I ask, what do you mean by that?
Meaning you filed a motion to change child support, but first I have to find there's adequate cause to do so. So you did file a motion for an adequate cause decision. Instead of making a decision today, I am going to move that issue to our November 1st docket. So you'll log back in 4 weeks, November 1st at 9 a.m. And then we will discuss that issue.
Okay.
Okay.
So meanwhile, I'm just stuck without pay and just deal with the consequences of barely having enough money to eat and stuff.
I'm sorry. I can't make out what you're saying. Can you repeat yourself? You're kind of in and out of audio.
I'm saying just meanwhile, I'm just stuck with whatever I get as income and just deal with it.
So I'll rephrase it differently than you. What I will tell you is that there is a final order of child support just from 2022. So you, up until I make a further decision, are bound by that 2022 order for child support. Yes.
Okay.
If you want to phrase that differently, feel free, but that's the court's ruling.
No.
Okay. Okay. So then let's move on to the review portion of this. And I'm just going to pull up my notes. So Mr. Lawrence, I guess I'll turn it over to you. I think if my notes are correct, the review portion of this case really involves Mr. Gutierrez and his evaluations that we're wanting to get done and see.
That's correct, Your Honor. I had a chance to speak with a representative of the Kaiser Outpatient Substance Abuse Program. And what she indicated to me was that Mr. Gutierrez was declining or not admitting that he needed any treatment. And I explained to her the court process and that we had requested input for myself and Ms. Gutierrez as well. And they indicated to me that as long as he is declining treatment, that, regardless of our input, that they are not going to put him through treatment. And so my understanding is that Mr. Gutierrez is no longer living with his sister, which he was at the time of my last report. He apparently lived with a girlfriend for a period of time, but is now basically floating and living with friends or in his car or whatever. And that was indicated to me by an email from Mr. Gutierrez here about a week ago. And so we have a situation where essentially he's homeless and is refusing treatment. And alcohol, his alcohol issues are kind of the heart of the issues in this case. And he has had no visits with his children as an incentive for him to get into treatment. And now apparently he's refusing it. So my only recommendation at this point is that the status quo be maintained until he does get into treatment and starts trying to improve his life.
So thank you, Mr. Lawrence. I appreciate that. Mr. Gutierrez, I want your input, and I'm looking back through the order, the history of this case and the order that a prior judicial officer entered suspending visitation pending drug and alcohol evaluations and treatment. So, I'm not inclined to make any changes to the suspension of visitation, but I would like to hear from you and get your input on this issue.
I have not declined any sort of treatment. I conversated with the counselor.
Hold on real quick. We're having the same problem. I am not able to pick up your audio well enough to understand what you are saying. Can you try to...
Give me 1 second, then.
That's better. Whatever you just did is way better.
Oh, okay. I have not declined any sort of treatment or anything at all like that.
Sorry, you just kind of cut out again.
Oh my God.
Can you stay close to the microphone on whatever device you're using?
Can you hear me?
Yes.
Okay. I have not declined any sort of treatment or anything like that. I spoke to the counselor. I did what I was supposed to do. I'm just waiting around to hopefully get my visitation time with my kids. I mean, I missed the whole summer because of this.
Right. So are you engaged in treatment with Kaiser?
Not at the moment. I mean, like I said, I've talked to the counselors and they asked me to do drug tests and stuff like that, and I done them all. If Mr. Lawrence or Alisa haven't received those results, I don't know what to tell you, because I have reached out to the counselor to email those to them as an evidence, and I just out of my hands, I guess.
Well, so here's what I would say. It's not out of your hands because this is your life, nobody else's. So it is, if the counselors are not sending reports to Mr. Lawrence, then I recommend you go get those reports from the providers and you get those to Mr. Lawrence. Because what I am telling you is I'm not going to make any changes to visitation until I see that you are in compliance with your evaluations and treatment. Okay.
Well, like I guess I just have to talk. I wasn't told to go on any kind of treatment or nothing like that. So I'm not denying to go into treatment at all. I'm just saying I did the evaluation like I supposed to. I mean, yes, it took a little longer than I expected. But I don't know what to do from now. I don't know what to do now.
Yeah. So what I'm telling you specifically to do is we're going to, since we're already coming back November 1st, I'll set another review date for this issue to November 1st. And so that gives you 4 weeks for you to proactively reach out to Kaiser about getting paperwork to Mr. Lawrence and or getting engaged in treatment and or getting drug test results to Mr. Lawrence. Because right now he's being told is that you're not engaged in any sort of treatment with them.
I mean, I don't feel like I need to. I mean, honestly, what do I?
Yeah, so Mr. Gutierrez, if that's your position, then we'll address that November 1. Just know that if Kaiser is stating that you're refusing treatment, I will take that into account when I make a decision about your visitation rights with the kids.
Okay, so what do I need to do? Do I need to go take drug tests and have those emailed to Mr. Lawrence? Is that what
What you need to do is reach out to Kaiser. You need to follow whatever treatment plan they have for you or whatever request they have for you, and then get that compliance notation to Mr. Lawrence, either through your counselor or by you taking the paperwork yourself from Kaiser and getting it to Mr. Lawrence. Okay. Okay. Alisa, any input from you?
Not really. I mean, I didn't know where all the new paperwork came from because we still had this current case open. So that's why I am just here to figure out why he's trying to re-petition the parenting plan. And
we will, I have looked through that motion. We'll address it on November 1st after the state looks at it.
Okay.
But yeah, we'll just essentially reset both of these issues to November 1st and see.
Okay.
Okay.
Sounds good.
Okay. Mr. Lawrence, anything else on this matter?
No, Your Honor.
Okay. All right. Mr. Gutierrez, Ms. Gutierrez, you're free to log off. Mr. Lawrence.
Matter as soon as I call another case.
Awesome. Thank you.
Okay. And then, do I have any other GAL matters other than Gutierrez left? Don't think so. Okay. Well, Mr. Lawrence, then I am going to come back to you on the Gutierrez matter. Let's see if I have the parties present. I do have Francisco Gutierrez. If you want to go ahead and unmute.
I'm here as well.
Okay. And then this is it Alyssa or Elisa?
Elisa.
Elisa. Okay. All right. So this is 22300096608. Let me just jump into your file quickly. Okay, so when we were last together, October 4th, I had set over any ruling. Oh, and we have Ms. Looney on this case too. Thank you. I had set over any ruling on the adequate cause motion because there was a concern, a pretty significant concern that Mr. Gutierrez, you weren't in compliance with any treatment. And there was a concern that you were declining treatment. I know we had a lot of discussions about what you would need to do in order to be compliant. Where, I guess first, Mr. Gutierrez, I'll ask you about any updates with treatment.
I don't have to take any. I'm not on any treatment. So I mean, I'm not denying or refusing to take any treatment. There was a paper that I got from the counselor, and I submitted it to the court. I don't know if you got that paper.
I do see that October 13th that does confirm what you are saying, that it was determined you did not meet any criteria for an active substance abuse diagnosis. There was no recommendation for treatment and your UAs had all been negative. Is that your understanding?
Yeah.
Okay. Mr. Lawrence, any updates since our last court hearing on this?
Yes, Your Honor. If the court recalls, I had requested not only that he undergo an evaluation, but that there be input provided by Elisa and myself in that evaluation. I had a chance to speak with the counselor from Kaiser, and she was not interested in any input from me. I don't know whether or not she was interested in any input from Elisa, but and I understand the technical aspect of this, that if he is refusing treatment, he's not ready, or they feel that he's not ready to be put into treatment, that he's not going voluntarily. And so her evaluation reflected that he didn't need treatment. And I think that is an error. I'm not a drug and alcohol counselor. However, in speaking with Elisa, all of the problems that have been generated in this matter have been the result of Julian's drinking. Their initial separation, the issues about the Memorial Day weekend fiasco. Ultimately, he ended up being, I guess, asked to leave his sister's home. And by his own admission to me, he is now floating between friends.
Can I say something about?
Sir, I'll come to you in a minute. Mr. Lawrence is speaking. I will ask for your input.
I think that the treatment is still necessary, and I would ask that the court not change the situation at this point until he actually gets into drug and alcohol treatment.
Mr. Gutierrez, I will come to you in a minute. Ms. Gutierrez, anything you want the court to know?
I feel the same as what Keith is saying. I don't feel that he's ready to have the kids alone because he won't get the help, and it continues. It's been going on for years, but he has been more consistently making his phone calls and reaching out to the kids. And I do feel like it would benefit them if they could get some visits, like in person. My aunt is more than willing for him to visit the kids with her presence. And he's done that before, and it was
perfectly fine. So I would prefer that he starts getting some supervised visits because it's already been 4 months and the kids are struggling with it. I want him to stop drinking completely, but that's just been a struggle that I've fought with for a long time, and he doesn't want to do that.
Okay. A second, I'm just going back. This case has a long history that predates me, and I was just going back to check.
Yeah.
The bench order. I know you guys have been involved in this for a very long time. The prior commissioner initially hearing this case had specifically Mr. Gutierrez put in the bench order that when he suspended visitation, that did require the drug and alcohol evaluation with collateral input from the GAL and Ms. Gutierrez.
Yes.
And so I guess, Mr. Gutierrez, I'd like to hear from you. It sounds like the counselor that you did an intake with did not want to accept that type of input. So when you had your evaluation, was it you giving the historical information to the counselor, or what did that look like?
It was just a normal conversation. She asked me about my drinking. She asked me about any sort of use of any other drug, and I just talked to her about my, just had a conversation with her, and I told her, I let her know that she needed to put input with Alisa and Lawrence, and I mean, if whatever she said, we'll talk to them. I mean, it was, that's out of my hands. I can't. It wasn't like I was telling her to say this to him or to Alisa. It was whatever conversation that had, I had nothing to do with it.
Mm-hmm. Ms. Gutierrez, were you able to speak with the substance abuse counselor?
No, nobody's reached out to me.
Okay.
I've tried to reach out to them to get some communication there, and they said that they couldn't communicate with me without his authorization. So
I told her, and I even emailed her, left voicemails to make sure that she gets a hold of Alisa and Lawrence. So I talked to her after, and she said that she emailed both of them and never got back to her. So I don't know. Maybe they're missing each other's emails, each other's phone calls. I don't know. And as far as
go ahead, Mr. Gutierrez.
I was gonna say, as far as my living situation, I'm currently staying with a friend because I can't afford a place on my own. I had to move out of my sister's place because I was paying her rent, and right around the same time to where I lost hours. I was trying to get a better schedule at work so that I can have the weekends off, so that I can hopefully get my visitation time back, and hopefully get a place of my own. But my hours went down. I do have a better schedule. I do have the weekends off. I just don't. I'm not working the 60 hours a week that I was working before. I'm cut back to 40 hours a week, and I can't afford, with the child support that was being taken out of my pay and other additional fees and debt that I'm trying to keep up with. My pay, I don't have, basically I don't have an income. I barely have enough money to put gas in my car to go to work and back every
day. Okay, I'm gonna kind of switch gears a little bit and go to Ms. Looney on the child support issue. I did see the proposed orders. And so I'm trying to kind of make sense of, is the state requesting those be entered as final child support orders or contingent upon the adequate cause motion?
So, Your Honor, this case, as you say, does have kind of a lengthy history. So the reason that we have filed proposed final orders is that each parent has separately filed their own motions for adjustment of child support. Mom filed hers back in January. Dad just filed his back in September. So we have filed that proposed final order in response to those motions for adjustment that the parents are requesting. So we would think that at this time it would be appropriate to address final child support as that request has been made by both of them.
Okay. And the most recent proposed order I have is signed October 6, 2023. Is that the most recent one I should have?
Yes, Your Honor.
Okay. So and then that order, is that based on assuming visitation the parenting plan doesn't change currently?
Yes, Your Honor. We were using the information we have with the current child support or the current parenting plan, with the father not having that split at this time. We also were looking at the fact that the mother and children had recently been on TANF. We do have a notation in there that if TANF does become an issue again, that we would ask that those payments be the way that they were.
Okay.
Trying to find that on my page, but we're just asking at this point to address that child support. We have based that on Mr. Gutierrez's year-to-date income from a pay stub from September 15th that he filed. So that is where we got the information for his income that we used for our proposed order, where we have him at a gross monthly income of $67.31 and a net of $42.61.
So let me hear from the parties briefly on the proposed child support order from the court. So first from you, Ms. Gutierrez, have you reviewed the state's proposed child support order?
I'm fine with it. I didn't ever care to mess with it.
You didn't
so
what?
Whatever it may. I didn't ever care to change it. He was the one that wanted to change it, but I'm okay with whatever they decide.
The current, and Ms. Looney, the current obligation, if this order is signed, would be for Mr. Gutierrez to pay $1,573 a month for all 5 kids total.
That's correct, Your Honor.
Okay.
That breaks down to $314.60 per child per month.
Okay. What's the current payment being made? Do you know?
It is
currently $12.40.
Yes, I was just looking in my file, and it is $12.40 at this point, Your Honor.
Okay. So, Mr. Gutierrez, what is your statement you want to make to the court about the proposed child support order from the state?
I don't know. I think it should be less, a lot less, so that I can afford to eat. I can afford to live. I can afford to get to work and back. I mean, instead of, should be cut in half if you ask me. Instead of $300 per child, I mean, for me to be able to comfortably afford a place to live and a place to have, so that maybe whenever I get my visitation back, to have my kids with me, it should be cut in half, maybe like $150, $160 per child, just so I can get up on my feet and start get my own place and start having a real visitation time with them.
Okay. Here's what I'm going to do, having reviewed the child support issue as well as the adequate cause motion from you, Mr. Gutierrez, to increase visitation. So first on the parenting plan / your request for 50-50 custody, I'm going to reserve ruling on that just until I am going to replace the requirement on you that whoever, whether it's your Kaiser substance abuse counselor or whether you need to go get a new one, the prior judicial officer's ruling that they had to accept input from GAL and from Elisa needs to happen. And the reason is very specific. So often in cases where perhaps, let's say criminal cases, where there's an allegation that someone has abused or is abusing alcohol, often we say, hey, get a substance abuse evaluation. The police report must be provided to the counselor. And the reason we do that is so that the recommendation is not just based on what the person is reporting to the counselor. I'm not saying that this is present in your case, but sometimes people will downplay their level of use of substances. And that's often a part of a substance use disorder. So in this case, because we don't necessarily have those other objective things for the counselor to look at, I am replacing the requirement that whoever does the evaluation that this court accepts must accept collateral input from the GAL and Elisa. And then at that point, I will reconsider your adequate cause motion. I hear Ms. Gutierrez stating that she wants supervised visitation between you and the kids. Is that something that you're open to currently, Mr. Gutierrez?
Yes, I would. The problem is, like I keep saying about my, as far as income goes, I mean, I can't afford to drive from Portland. I work by the Portland airport, and I can't afford to drive from Portland to Longview every day. Well, not with the car that I'm driving right now. I can't afford that. It costs me like $100 every 4 days to do that. So, you know, as far as visitation, I mean, income is a big factor here for me. I'm really struggling with. It feels like I'm just working for nothing.
Okay. So it sounds like supervised visitation wouldn't be financially feasible for you right now.
I mean, I could work with that, but I mean, I would have to, I don't know, I guess use credit cards or something to be able to afford it.
Okay. What I'm going to put in my bench order is that, Mr. Lawrence, how would you typically word the supervised visitation allowance that we're going to do temporarily pending a substance abuse evaluation?
Well, that verbiage is fine. I would use the term that the supervisor be somebody that can be mutually agreed upon by the parties.
Okay. Do the two of you have a third party that you would both trust to do supervised visits?
The hours that he would be allowed to visit them while I'm still at work, they'd be with my aunt, who's also certified through the state to take care of them. And she's okay with that, and she's always been a mutual party.
And what's your aunt's name?
Sabrina Valencia.
How do you spell the last name?
Valencia.
Okay. And then when Ms. Gutierrez, do you want to put specific days and times on supervised visitation, or what is your request?
Monday through Friday is fine, and then he can see them after work until about 6 p.m. is when I get them from her.
So he could coordinate his visitation directly with Sabrina?
Yeah, she's totally fine with that. And I understand that he probably won't be able to make it every day. I just want it to be available for him so that if he can, he can.
Okay.
I know that his mom has mentioned that she's willing to help him if getting gas is an issue, she's willing to help him with that.
Okay. So that's what I'm going to do temporarily, Mr. Gutierrez, on visitation until we are able to get a substance abuse evaluation that meets the court's criteria. So I'll do a bench order to that effect. I am going to find adequate cause to modify or re-review the child support order based on the mutual parties' request. I do find the state's order as proposed comports with the income that the parties have reported. So I am signing that child support order today.
Your Honor,
oh,
we did leave in the, Your Honor, I apologize. We did leave in the deviations section because it appeared that Mr. Gutierrez may have additional information he wanted to share. I don't know if Your Honor wanted to ask him more questions about that. If you are going to decline granting a deviation, we would just ask that it be marked no and that there was no good reason to approve the deviation requested.
And I do see that on page 2, and I'm just looking to see
it goes over to page 3 as well.
And into 3. Okay. So Mr. Gutierrez, you have indicated, so this new child support order based on your actual income from your pay stubs would put your total support obligation at $1,573 a month. You have asked, I believe that you are asking for the court to deviate from that standard calculation. Is that correct?
Yeah, I like I said, I think child support should be half that because
Why?
I need be like I keep saying, I mean, I would like to be able to afford a place, a 1-bedroom, a 2-bedroom, to live and have my kids over whenever I get my visitation time back.
Well,
so have my kids and
so what I'm specifically asking you though is about why you can't afford that money based on your income. Do you tell me about your other household expenses? Tell me about where your other money goes. What is it that causes you to tell me you can't afford $300 per kid?
well, as of right now, before Lisa and I separated, she took it on herself to put 3 of my kids' phone on my phone plan. So I'm paying for 3. I have been paying for 3 of my kids' phones so that I can be in touch with them. Before Lisa and I separated, there was a personal loan for $5,000 that I took out for car repairs on the car that she kept, and I'm still having to pay on that too. And there's also
how much do you pay on that?
On the personal loan?
Yes.
It's $240.
Per month?
Yes.
Okay. Any other extraordinary debt that you're paying on?
There's credit cards that I have to use, and there's also I try to explain this to the child support people. There's also during the months of October, November, and December of 2022, I did not give Elisa a child support check because she was behind on bills. So instead of paying her the child support check, I paid the mortgage for those 3 months. So according to the child support intel people, they don't care about that. So I'm still being charged for those 3 months for back child support when I paid the mortgage. I made the mortgage payment instead of paying Elisa child support check. So I'm still being charged for that back child support. And now I'm like between the cell phones, a personal loan, and credit cards, I'm struggling to keep up.
Okay. So I am declining to do any deviation. I find that $314 per child is exceedingly fair given your income. I think the other reasons you've given me are based on you essentially wanting it cut in half, which is not fair to the parent.
Well,
Hold on, I'm not done with my ruling, sir. Which is not financially fair to the parent who is primarily supporting the children. But also the debts that you are discussing with me, I am finding were voluntarily incurred and not unexpected or extraordinary expenses. So I am signing the child support order as proposed by the state. I will have to do an order granting the adequate cause based on the request of the parties for that, and I will get that done today as well.
Okay, so
let's set a review date. I'm going to hand those up. Let's set a review date for the adequate cause motion on the parenting plan. Certainly, how long, Mr. Gutierrez, do you think you will need to either get a new evaluation that will accept input from the GAL and Elisa, or talk to your Kaiser counselor about accepting that input?
So, can I ask something really quick about that? Do I need to go get a new counselor? Because that's going to take more time if I need to go find a new counselor.
If your Kaiser counselor won't accept the court's requirement that she or he take input from the GAL and from Elisa, then yes, you would need to get a new counselor or new evaluation, excuse me.
I don't know. All
right. Then if you don't know, let's set this to December 13 at 9 a.m. if that works for you, Ms. Gutierrez and Mr. Lawrence.
Yes, it does. I just had one other question for you.
Go ahead.
Is there any way for me to be able to have any type of communication with him? Like, is there like an app that can be monitored? Because the state put in a protection order. He's not allowed to contact me because he was charged with domestic violence.
Right.
So right now it's like he can only call the kids' phones. And it's kind of hard.
For coordinating stuff about the kids?
Yeah.
Would Sabrina be willing to kind of be a go-between? I could put in my, well, let me rethink that. I might not be the proper venue for you to request that. If you're telling me there's if there's a criminal no contact order in place, you'll need to seek a modification that allows third-party contact through the prosecutor's office.
Okay.
Handling that case. So I would encourage you to do that.
Okay.
All right. So we'll see the parties back on December 13th at 9 a.m.
So,
all right. Thank you very much.
Yes, Mr. Gutierrez, I need to wrap this case up.
I'm just gonna, maybe a stupid question, but so you're gonna make my child support get higher, like pay more, basically.
Yes, your child support obligation is $314 per kid. Yes.
Okay. That's great. Thank you.
You're welcome. We'll see you back on the 13th. Okay, let's go to Mr. Lawrence. I have you on a couple cases here. We'll go ahead and take those. The first one I have, number 1 on our docket, is the Gutierrez matter. Do we have Alyssa or Francisco?
Your Honor, I believe Francisco is on, but I have not seen Elisa.
There is someone logged in with an iPhone that doesn't have a name on it. Can you unmute and tell the court your name? Oh, there's also an iPad. If you are on Zoom, oh, go ahead. I see the iPhone unmuted.
My name's Heather Lucor.
Okay. Oh, okay. We'll come to your case. You are the very last on our docket. I have 2 cases before we get to yours.
Okay.
Okay. Thank you.
Yep.
And then there is an iPad, sir. What's your name? You're muted. Are you Ryan? Yes. Okay. We'll come to your case here at the end of the docket.
Thank you. I'm sorry.
There you are.
I didn't know how to unmute it.
No problem. We have 2 cases before yours, and then we'll get to you.
Thank you.
Okay. So I don't see Ms. Gutierrez here. I have this on for a review hearing. Mr. Lawrence, what are you able to tell the court?
Well, as the court is aware, we've been having hearing after hearing. As the court had asked Mr. Gutierrez to obtain a drug and alcohol evaluation, and we had him go about a month ago, and the counselor did not want to take input from myself or Ms. Gutierrez. And the court reiterated that he needed to complete the evaluation. I did receive contact about 2 weeks ago from Kaiser, and they took my input, and I sent a copy of my guardian ad litem report to the counselor. And I have not received any word that the evaluation is completed, and haven't received a copy of it if it has been.
Okay. I appreciate that input. Mr. Gutierrez, what do you know that might be in addition to that information? Mr. Gutierrez, you might be muted. I can't hear you. Mr. Gutierrez, do you want to try and log off and log back in to see if we can get, oh, there you are. I see video now. We cannot hear you. We still don't have audio. We have video though. Let me, oh, there, now he disappeared. Let me see if he comes back into the waiting room. Mr. Gutierrez, can you hear the court? Oh, he's connecting to audio.
Hear me?
Yes, I can.
Can you hear me now?
Yep, we can.
Okay. All right. Sorry about that.
Nope, you're fine. So what can you tell us? Any update on the evaluation process on your end?
I believe I thought that was done. I didn't know. Counselor talked to me after she spoke to Lawrence and Elisa. Okay. And she told me I had a phone call with her and informing me that it was done. So I don't understand the communication between the counselor and Lawrence, or the communication between the counselor and Elisa. So I don't know.
Well, here's my thought, because we do need that input and it does impact your case. So I would implore you, a lot of times people tell me, oh, I expect the counselor will reach out to the GAL. And I always say, since this is your life and your case, I recommend you reach out to your counselor and make sure that they're getting what they need to the GAL. Okay. So my thought is we do a short set over, especially since we don't have Ms. Gutierrez here today. For unknown reasons, I will note that she has appeared at every other date. So I don't know what happened in this specific instance. So I'm not going to take action today. Let's do a short set over. And Mr. Gutierrez, if you can get a hold of your counselor and just make sure they're in touch with Mr. Lawrence, that will be really helpful for us moving forward.
Can I ask Mr. Well, I guess I can do it. I don't have to do it on here. I don't know what he wants from the counselor, but okay.
Yeah, why don't you reach out to Mr. Lawrence? He can certainly clarify that for you. He has no problem doing that.
Your Honor, all I need is a copy of the evaluation.
Is that helpful to you, Mr. Gutierrez?
Yeah.
Okay. How much time do the parties want to do that? And I think one or both of you, if you could reach out to Ms. Gutierrez with this date, that would be helpful too, so that we can move forward.
I can do that, Your Honor.
Okay. I mean, I could set this over just 1 week to December 20th if we think the evaluation's been done. Or we could go out 2 weeks to December 27th if folks are available. Again, like I said to the Prior case, I know that week between Christmas and New Year's is a tricky one for folks.
I should be available.
Mr. Lawrence, what's your
Yeah,
holiday
I'm
availability?
I'm available, Your Honor. I don't know what Lisa's schedule is or how involved it may be to get the report, but why don't we try for next week?
Okay. Let's try for December 20th. So Mr. Gutierrez, if you could reach out today to the counselor and just let them know Mr. Lawrence is needing that report, we might be able to move forward on the 20th. Okay.
Okay.
So we'll just set this review over 1 week to December 20th at 9 a.m.
Thank you, Your Honor.
Okay. Thank you all.
Thank you, Your Honor.
Thank you. And then I also have another review matter, number 3, the Gutierrez matter. Mr. Lawrence is on that case with us. Do I have Elisa Gutierrez and Francisco Gutierrez?
I'm here.
And
I'm here.
let's see, Mr. Gutierrez, what account are you under? I'm not seeing your name.
I'm on my phone.
I see you now. We have so many people on screen. I just had to see it light up when you talked. And I know Ms. Gutierrez, when we were here last, we were missing you.
Yeah.
So what we did, I know that you had been at all prior hearings. I wasn't quite sure what had happened, but essentially what we were waiting on at that time was Mr. Gutierrez and his counselor, particularly the counselor, to get more information to the GAL. So we just went ahead and set today as the review date for that information. Okay. So Mr. Lawrence, go ahead.
Your Honor, at 3:56 p.m. yesterday afternoon, I received an email from Julian, and he had forwarded his evaluation from Kaiser. And I believe he also forwarded a copy to Elisa. It indicated that he did have a relatively minor problem with alcohol. They were recommending outpatient treatment for him. And I wasn't aware whether Elisa had gotten a copy or not. So I forwarded my copy to her and reminded her of today's court date. I'm sure that Mr. Gutierrez has not had a chance to file it with the court, and I may have to file it so that the court has a copy in the file. But right now, that's where we stand.
Okay. And then that outpatient treatment, is that something that's been undertaken or is happening, or do we know?
Your Honor, I don't know at this point. Mr. Gutierrez will have to answer to that one.
Okay. Mr. Gutierrez, what can you tell me about any treatment follow-up?
As far as right now, I don't have any treatment. What the counselor said to me was that it's just considered a level 1 outpatient treatment, and it's pretty much like up to me if I want to do it, or basically up to, I don't know, the court. If I'm being ordered to do it, she just said it's just a level 1 outpatient recommendation. At this point, I feel like I guess part of it is up to me, I guess, and part of it is if I'm being ordered to do it. I just don't know.
So I don't have the documentation in front of me, but I'll tell you just in my experience, both as an attorney and a judge, that typically evaluations like this are written in terms of recommendations. So a
A medical provider is never going to say, I order you to do level 1 outpatient treatment, but certainly the court's expectation when we require evaluations is typically you get the evaluation, the expectation is that you comply with the treatment recommendations. So I don't know if the word recommendations is what's tripping you up there, but it is this court's expectation that you would comply with the recommendations of the professional. Is that helpful to you?
Yeah, I guess I'll have to do it.
And Mr. Lawrence, since I haven't seen that document, is that accurate that following the evaluation, it's level 1 outpatient is listed as the recommended treatment plan?
Yes, Your Honor.
Okay. So my thought on this case, Mr. Francisco, is to set a further review date to just check your compliance with the level 1 outpatient treatment, which is one of the lowest levels, so it should be pretty easy for you to accomplish. How does that sound?
I'll look into it after I'm done here.
Okay. How much time would you want to get that started? And we'll just set your next review date accordingly.
I'm hoping sometime next week. Like I said, I will reach out to the counselor. I'll reach out to whoever I need to, hopefully by the end of today or the end of the week, and get this thing started for myself. Excuse me.
I'm going to set it out a little more than 1 week, just because although you might have answers about when and how to start the level 1 treatment, I don't think you'll actually have started that. So my proposal would be that we set this out to January 17th at 9 a.m. if the parties are available for review.
I think that's fine.
Yeah, I'm available. Yes.
Okay, great.
I'm available as well, Your Honor.
Okay, great. Thank you all for that. So what we'll do, Mr. Gutierrez, is just your only task for the review on the 17th would just be to give an update, hopefully showing that you've been started to engage in some of the level 1 treatment. And then we'll go from there, okay?
All right.
Okay. Anything else we need to do on this matter?
I don't believe so, Your Honor.
Okay.
There
is anything from you?
No, he's been doing very well at staying in contact with the kids and showing up for visits now, so I'm very pleased with that.
Good. And we still have Sabrina supervising.
Yeah.
Okay. Mr. Gutierrez, go ahead.
I just have a question about basically the bills that have to do with the house. I don't think Elisa has removed my name of all the bills, which they're still being forwarded to me. And I don't know if I should be talking about that here to you or with Lawrence or.
Well, so we're here just on an adequate cause to change a parenting plan. My understanding is you all back in June of 2022. I'm just going to check to make sure this is accurate. June 2nd, 2022. You guys do have a decree of dissolution that controls debts and all of those things, real property. I don't know if you're talking about the 48th Avenue location.
Yes, I am.
Okay. So go check your June 2nd, 2022 divorce decree or decree of dissolution. It does list specifically each of your obligations with regard to that property.
Okay.
Okay. All right. Thank you so much. We'll see you back on the 17th.
Next matter I have is Alyssa Gutierrez and Francisco Gutierrez, 223-9608 is the cause number. There we have Mr. Lawrence as the guardian ad litem. He is present. I'll ask if Alyssa Gutierrez is present. Alyssa Gutierrez, are you on the line? Ms. Gutierrez, if you're on the line, I can't hear you. Make sure you're unmuted. Pressing the icon for the microphone or dialing via phone number, you can press *6 to mute and alternatively unmute. So Alyssa Gutierrez, are you here? Okay, not hearing a response. And Francisco Gutierrez, are you on the line?
Yes, I'm here.
Okay, well, welcome to you, sir. All right, so we're here to review Mr. Gutierrez's SUD, or Substance Use Disorder Treatment Program. There was an evaluation apparently completed in November of 2023, and that was filed on December 29th of 23. It recommends outpatient treatment. It makes some observations related to that. So I reviewed that, and those were kind of those screenshots that I think Mr. Lawrence may have filed. I'm not sure, but I did look at those. So I'll hear from Mr. Lawrence first, and then hear from Mr. Gutierrez.
Your Honor, we are here today to review Mr. Gutierrez goes by his middle name, Julian. Here to review Julian's progress in his treatment. I spoke with him by telephone on Monday, and he asked when would be the latest time he could get the results of that to me. I indicated that I was going to be gone all day yesterday, and and I asked that either he or his counselor email me something about his compliance. He told me that he had a 10 o'clock appointment with his counselor yesterday morning. And so when I got back from being out of town yesterday, I checked my email, and I checked it again this morning, and there's no, I don't have an email from either Mr. Gutierrez or from Kaiser, his treatment provider. So I don't have any information to offer the court about his compliance.
Thank you, Mr. Lawrence. Mr. Gutierrez, what can you tell me about your compliance?
I had a really busy day yesterday. I been meeting with counselor every 2 weeks, and yesterday, like I said, I had a busy day between work and getting stuff done. I haven't checked my KP at the website to receive a letter or a statement that I can forward to Mr. Lawrence. I need to check that so that I can.
When did you start treatment?
January, no. It was the week before New Year's Day. It was the week before New Year's. I believe it was the December 26th, I believe. December 20 or 28. I can't remember. I have to go back and look.
How many sessions have you had?
3 so far.
Okay. And have you asked Kaiser for a letter updating the court with your treatment compliance and progress?
Yes, I did. I did that yesterday, and I did not see a letter in the afternoon after I got off work, and I've been doing other activities on working on myself as well. So I just, like I said, I had a busy day. And when I talked to Lawrence about him filing or trying to, how do I say it, put in whatever statement he needed, he said if it's not turned in by Thursday, it's too late. So I figured maybe, I don't know, next week or whatever other next court day, I could show proof of this evaluation or counseling that I've been doing.
Okay, thank you. So, Mr. Gutierrez, I'm a little bit concerned by the fact that on December 20th, you were here and we set January 17th as a review date to check your compliance. You've had an extra week from then until now to provide us with a letter of compliance. You've indicated that you asked yesterday for Kaiser to send the court an updated letter regarding your compliance. Obviously, things don't turn around that quickly in any large organization. So I'm concerned that you haven't supplied that. So you've made that request now. So that's good that they'll supply an order. So I'm going to set this matter over 2 weeks to February 7th at 9 o'clock, and we'll need to have that letter filed. And so everybody can review it prior to that date. So get that letter. We'll review it on February 7th at 9 a.m. Any questions?
Can it just be next? Can it just be next week, and I can provide this letter either today or tomorrow?
February 7th is the date. We'll review it at 9 a.m. Any other questions?
No.
Mr. Lawrence?
No, Your Honor.
All right, that'll conclude today's hearing. We'll see everybody then.
Thank you.
The Gutierrez matter, if we could call that next. That is Alyssa Gutierrez and Francisco Gutierrez, 223-9608. I'll ask if the parties are present. Alyssa Gutierrez, are you on the line? All right, if you're here, Ms. Gutierrez, if you'll please unmute your phone and state your name. Not hearing a response. There's nobody in the courtroom other than the court clerk and myself. And then
I'm here.
And I'll ask if Francisco Gutierrez is present.
I'm here. Can you hear me?
Yep, I can. Thank you. Welcome, Mr. Gutierrez. We're here to review Mr. Gutierrez's treatment. Looks like there is a parenting plan issued back in June of 2022. And then there's a petition to modify the parenting plan by Mr. Gutierrez filed in September of last year. Ms. Gutierrez responded to that. And back on October 4th, there's a court ruling that indicated there is no change to the visitation until Mr. Gutierrez complied with treatment. Court ruled on November 1st. It was reserved or was holding off on making a ruling on the parenting plan, but did make a finding of adequate cause. And then back in December, late December, when we were in hearing, Mr. Gutierrez represented that he would be starting treatment that very day. And then on the 24th of January of this year, we had not yet received any updated proof of Mr. Gutierrez's compliance with his substance use disorder treatment. And the court indicated that it was interested in having some type of letter from the treatment provider addressing compliance of Mr. Gutierrez. So I'll look to Mr. Lawrence first, and then to Mr. Gutierrez for updates related to compliance with that SUD treatment.
Your Honor, I spoke with Mr. Gutierrez last week by telephone. He wanted to know what needed to be provided for today's hearing. And I indicated to him that the court was interested in seeing his progress in substance abuse treatment. So he said he was going to be meeting with his counselor. Yesterday, I received a voicemail from his substance abuse counselor at Kaiser, leaving a message for me to contact her. I did. I left a voicemail for her, and we seem to be playing telephone tag, and I haven't seen anything in writing, and I haven't had an opportunity to speak with his counselor.
Okay, thanks. Mr. Gutierrez?
Yeah, can you hear me? Sorry, I don't know if I mute or unmute this thing.
Yeah, I can hear you. I can hear you clearly.
Well, I've been doing the counseling sessions, and following by the evaluation, I've been asked to. I know the last week it was on my end, it was late for me to turn in a letter that I submit to Mr. Lawrence about what I've been doing and how things have been going for me. And yesterday I met up with my counselor again, and I asked her for what Mr. Lawrence asked about a letter of my progress and how things been going. And all she said, I just need to speak with him. So, and that was the end of at the end of that conversation that I had with my counselor yesterday.
Okay. All right. So just going back to Mr. Gutierrez, you filed a motion to modify the parenting plan. An adequate cause was found on that, but we've kind of been stalled waiting to get an updated information related to your treatment compliance. Usually the best information is written documentation. Treatment providers do that regularly. That's not uncommon that they provide written documentation stating how a person's doing in their treatment, what progress they're making, or any difficulties that they're having, and that's submitted and filed with the court. So once we have that information related to your treatment compliance, then we can look at your motion to modify the parenting plan. But until we have that information, I'm not going to look at your motion to modify the parenting plan until we get that information submitted. So I'm going to leave the effort in your hands to get that information submitted and then noted up for a docket. I'm not going to continue to keep setting it over unless that information is presented to the court. Do you have any questions on that, Mr. Gutierrez?
Yeah, about the parenting plan and stuff like that. Does that still include the request to either change or lower the child support on my behalf?
Yeah, that's part of it. Yeah, you filed a
Okay.
petition to change the parenting plan, I think, to a 50-50 plan, and then you're also asking for a child support adjustment, correct?
Okay, because I mean, I'm working on this. I've been working on my obtain my kids' visitation, regain that, and I still don't have a place of my own to live. So I just would like to have that to be able to provide for them when they're on my watch, when they're with me. But I'll keep working on this. Uh, what do you call this counseling?
It's proof of compliance. Proof of compliance that you're involved in SUD, substance use disorder treatment, and how you're doing in the same.
Yes, I'll keep working on that, or try to obtain the results and proof and information for you guys.
When do you think you would have that? My concern is these things are lingering. This motion is lingering. It was filed in September, and
yes,
in November. Now we're already in February. I want to address that motion, so I'm kind of pulling back from leaving it to your hands, and I'm going to push it a little bit more. So you can tell me when you can have that letter and when we can have that hearing.
Well, that's kind of in the air right now because counselor she would like to speak with Mr. Lawrence, and that's kind of where it's at. So it sounded like it's almost like she wants to talk to him about this whole thing, and I guess I can try to jump in there and get Mr. Lawrence with my counselor to get them to talk to each other, and hopefully that could happen before the end of this week, before Friday.
Okay, I think it's great that there's verbal communication. However, the courts tend to be kind of written document preference. So I need to have your SUD treatment provider submit a letter or write a letter, and he or she can send it to you or send it to Mr. Lawrence, giving an updated input related to your treatment compliance. I think it's different when people sit down and write something. They know it's going to be in writing. It's going to be there forever. So I think they take greater care as opposed to just a verbal exchange. So the verbal exchange, I'm not preventing that. I think that's fine. But there also has to be a written document submitted by your treatment counselor telling me how you're doing or not doing in the SUD treatment.
Yes, of course. I will do my best to try to get Mr. Lawrence and my counselor in touch with each other, and hopefully I can obtain a letter either to me or to Lawrence or so that I can submit something to court and move forward with the next step with all of this.
Okay. I'm proposing a March 6th review date, and that's going to be the last time we review it. Either we have the information at that time or we're not moving forward. So make sure that that letter is in by that time, March 6th, the letter from the SUD treatment provider telling me how you are or not doing in your SUD treatment. I'm assuming you're doing well and you're compliant, but I just need to have that in writing. And if you're therapist wants to speak with Mr. Lawrence, that's fine too, but I definitely need that submitted letter, and it has to be filed with the court, and a copy has to be given to Mr. Lawrence and also to Ms. Gutierrez.
March 6th, you said?
March 6th at 9 a.m.
Okay.
Does that date work for you, Mr. Lawrence?
Yes.
Any concerns with that course laid out?
Nope.
Okay. All right. Very good. So we will see everybody March 6th. Look forward to receiving that letter from the therapist, and we'll see everybody then.
Thank you, Your Honor.
Okay.
Thank you. Next matter is Alyssa Gutierrez and Francisco Gutierrez, 223-9608. Alyssa Gutierrez, are you on the line?
Yeah.
Okay, welcome to you, Ms. Gutierrez. And then Mr. Francisco Gutierrez, are you on the line?
Yes, I am.
Okay, welcome to you, sir. And I see that Mr. Lawrence is present. You can hear me, Mr. Lawrence?
I can.
Okay, great. Just reviewing just briefly, I've received a document. It looks like it was dropped off yesterday. I reviewed it this morning. It's a report. Well, it's a report from Kaiser Permanente that Mr. Lawrence submitted related to a service provider providing SUD services for Mr. Gutierrez. And I'll ask Ms. Gutierrez, did you receive a copy of that document?
No.
Okay. She's in now. Thanks.
I
Okay.
apologize, Your Honor. I received it late on Monday, and I was gone most of the day yesterday, and I did file one with the court. I assumed, since the court had told Mr. Gutierrez to provide one to Alyssa, that I assumed he had already done so.
Okay. Yes, let me double check with Mr. Gutierrez. Mr. Gutierrez, I see here this is a letter from Ms. Where is it? Pozuelos, and it's dated March 4th. So did you submit that document to Ms. Gutierrez?
No, I did not. I've been having some busy days, and I totally spaced it. It was just over my head. I forgot. That's all.
Okay, so it's interesting that Mr. Lawrence took it upon himself to submit this, which is appreciated, but it's really not his duty. It's Mr. Gutierrez's duty to submit this document. So when I reviewed the case, nothing was filed, and this is kind of key because there's a proposed parenting plan to modify the parenting plan that's been pending since September, and we've been waiting on Mr. Gutierrez to submit documents related to his treatment compliance. And then it sounds like Mr. Gutierrez is just kind of too busy to provide the court the information that it needs. And so the court's a bit frustrated that this is an ongoing process that doesn't seem to take a lot of importance in Mr. Gutierrez's life in getting documents to the court.
May I say something about getting documents to Alisa? The issue is that there's a no contact order between me and her, so I can't do that.
Can you obtain a letter from the treatment provider more than 2 days before the hearing?
Okay. Yeah, I can try to do that.
So here's where we're at. We have some information from a treatment provider related to Mr. Gutierrez's substance use disorder treatment. And we have very limited information or declarations from the parties related to the parenting plans of what you would like to see. When I reviewed the case last night and again this morning, I saw that there was the petition to modify the parenting plan, and then there was a response to that. So there's very slim information the parties have provided the court. Generally, the court will have declarations from each party of why you want a particular parenting plan and what's in the best interest of the children and giving details. But I don't have a lot of details from either party. And Mr. Lawrence, your report was last submitted before the adequate cause finding was found, correct?
That's right, Your Honor.
Okay. So at this point, Mr. Gutierrez and Ms. Gutierrez, The court's not in a position, especially with the late arrival, which is appreciated that it came, the late arrival of the provider's information related to compliance. I need more information from the parties. And so I'm going to just ask both of you if you can submit declarations related to your proposed parenting plans and why you feel those are in your best interest, and submit those to the court, and then supply copies to the other party. I'll hear first from Ms. Gutierrez.
That's fine with me.
Okay, Mr. Gutierrez?
Yeah, that's fine.
Okay. Mr. Gutierrez, when do you think you could submit that document to the court?
By the end of this week, I hope.
Okay, and then you would file that and then provide a copy to Ms. Gutierrez?
I can somehow try to do that, yeah.
Okay. And then Ms. Gutierrez, as far as your timeframes in getting something submitted to the court after you've received Mr. Gutierrez's document, how long do you think it would take?
As soon as I receive it, I can file my information.
Okay, all right. Mr. Lawrence, any comment on the timing? I'm thinking March 20th is the time frame.
That would be fine, Your Honor.
Okay. All right, so Mr. Gutierrez, you'll need to submit to the court no later than Friday, March 8th, your declaration. And then Ms. Gutierrez, you'll have to submit yours no later than March 15th, and supplying a copy to Mr. Gutierrez, and also both parties supplying copies to Mr. Lawrence. So we'll be here on March 20th at 9 a.m. to hear the motion for modification of the parenting plan.
All right.
Any questions from either party or any of the parties?
May I ask, what number form is that, just to be sure about it?
As far as if you're looking at the Washington Court's website, I'm at the Washington Court's webpage under the form section. I typed in declaration, and there's not a specific one there. So it's a fairly nondescript document in that it says declaration of. You put the name of the person who's giving the declaration, and then you just write out the information you want to share. So you can look at the court's website to get to kind of the general form, but it's pretty much just an open document that has to be made under the penalty of perjury. So generally that's, you make your statement, and then at the end of your document, there's a language that says that you make the foregoing under the penalty of perjury.
Okay.
Any other questions?
No.
Okay, we'll see everybody on March 20th at 9 a.m. Thank you.
Thank you, Your Honor.
All right, thanks for your patience. All right, great. We're back on the record. Thanks, everybody, for your patience. Next, I have Alyssa Gutierrez and Francisco Gutierrez, 2239608 is the cause.
I did.
And looks like Ms. Long is present, and you go by Ms. Long now, correct?
Yes,
Great,
thank you.
appreciate that. I see Mr. Lawrence is patiently waited. Thank you. Mr. Lawrence is here also. And Mr. Francisco Gutierrez,
yes, I'm here.
are you here? All right, great, thank you. All right, so just I note that we're here today. We had a hearing on the 6th of March related to Mr. Gutierrez's motion to modify the parenting plan. And at that hearing, I asked the parties to provide additional information related to any proposed parenting plans. And it looks like I had indicated that Mr. Gutierrez would have to file his input by March 8th. I don't see anything that he filed. I did see that Ms. Long had filed a document on the 15th, a two-page declaration that she filed. So I don't know if we're in a wholly better situation than we were before. I think we have a little more information based on Ms. Long's declaration, but I didn't hear anything additional from Mr. Gutierrez. Mr. Gutierrez, did you file something and I just didn't get it?
Yes, I did.
Okay, what did you file?
A declaration paper that you asked me to file.
Okay, how many pages was it?
It was just the two-page, I think it's Form 101 page.
So I see the two-page declaration you filed back on March 6th. It says, I'm the father of Carson, Nathan, Isaac, Luke, and Stella.
I believe that's what.
Is that
I believe that's what you wanted, right? That's what you wanted me to do, the declaration form.
So that's the same day of the hearing, you signed it and you brought it down, filed the same day just after we got off the call.
Yes, I got off work and I drove to Longview and I did that.
Okay, all right. And Ms. Along, did you get a
Yes, I
copy of
did.
that? Okay. And Mr. Gutierrez, did you get a copy of Ms. Long's 2-page declaration?
Yes, I did.
Okay. And Mr. Lawrence, did you get a copy of
No,
those
Your
documents?
Honor, neither. I did see Ms. Long's filing yesterday when I reviewed the file, and I did not catch Mr. Gutierrez's filing.
Okay. All right. Well, I'll be transparent with you. When I was reviewing the file, I know we had that hearing on the 6th, and I know that I was anticipating something being filed by Mr. Gutierrez by the 8th. So I was looking for something post-dated from March 6th. So I wasn't necessarily looking back at that March 6th because Mr. Gutierrez was right on it, came down here and submitted that. He indicates that he's been doing and trying his hardest to comply with everything the court has asked him to do to obtain visitation with my children. I miss them as much as they miss me because of court regulations and financial regulations. I am missing out on my kids, spending quality time and making memories with them. They do not consistently have their father in their lives at the moment. With a fair support calculation and parenting schedule, stability and quality time will be restored and our father and daughter son bonds will strengthen. So that's what he wrote. And then Ms. Long wrote, I'm aware that Francisco is in compliance with his rehab program through Kaiser. I think it's in the best interest of the children that we go back to our original parenting plan. Do not feel that any modification to the parenting plan would be beneficial to any of us. Currently and also in the past, Francisco has been very inconsistent with his visits. I've already spoken with him and would be okay removing his weekday visits and giving him every weekend due to his work schedule. I feel that he needs to prove he's capable of showing up and doing his visits every other weekend with current parenting plan. If he can show 6 months of consistency, I will not contest a modification for every weekend. As of today, I would like to follow our original parenting plan and go back to unsupervised visits. In the past 30 days, he's only seen the children once and he spoke to them on the phone 3 times. Children need consistency. He needs to prove that he can do that for them. So that's the new inputted information. Mr. Lawrence, with that, I recognize you're just hearing that for the first time. I don't know if you're in a position to comment or if it would be premature.
Your Honor, I apologize if I miscommunicated. I did have a chance to review Ms. Long's statement. Yeah. I don't object to Ms. Long's suggestion. My only concern, and I would ask the court to adopt a recommendation that if the court decides to go back to the old parenting plan temporarily, that Mr. Gutierrez continue in his drug and alcohol treatment and that he supply Ms. Long with compliance reports so that she is aware as to his progress.
Okay. All right. Thank you. And then let me clarify with you, Ms. Long. In your declaration that you filed, you indicated that you wanted to go back to the parenting plan from June of 2022. And then you also indicated that you were open to every weekend, but then you kind of backtracked on that. So I'm not quite sure what you're wanting.
So
Is this
I know
the
that
original parenting plan or every week?
So I want to stick to the original plan just to make sure that he's really capable of doing it, because as of right now, like, he's not showing up for visits. He's not calling. The kids ask for him all the time. So it's like they have to call to try to get a hold of him. And he's brought it up that he wants more time with them. And I understand that he works and he's living out in Gresham. So it is kind of hard and inconvenient for him to make it out here during the week. So I think that if he can prove that he'll at least do his every other weekends, I wouldn't be opposed to giving him the weekends and just having him during the week.
But you want to see compliance before making every week. And so
Yes.
until that time, you want to see it
Yes.
alternating weeks.
Because he wants child. I'm fine with that eventually if he can prove that he actually will take them.
Okay. Thanks. Mr. Gutierrez, as far as the schedule, what's your preference?
I have no problem. I would love to have my time with my kids every weekend. I spent the last month trying to make my way however I can afford to be able to live in Vancouver. I live in Vancouver now for about 3 weeks now, so I could be closer and closer to my kids. If there's a chance for me to be able to afford to live in Longview, I would take that. But at the moment, I can only do so much due to my financial situation.
Sure.
And I would have no problem to make time with my kids every weekend, or I'll take every other weekend for now.
Okay. So as far as housing, you said that you're in Vancouver now. Can you tell me what your housing situation is?
I stay with a girlfriend of mine, and it's a little difficult on my financial part. Basically, I just stay there because she lets me stay there.
Gotcha. Does she have children?
Her children, she has a daughter that lives with her, and she's 21 years old, and that's it.
Okay. Any other individuals that live in the home?
No, just her daughter, and me.
Do you know if your girlfriend has any criminal history conviction?
I believe she's had a DUI in the past, and that's about that. That's about that. That's about it.
Okay. As far as the daughter, 21-year-old daughter, any criminal convictions that you're aware of?
No, not at all.
Okay. And is there, and forgive me just one moment, the children we're talking about here are now, there's 5 children, ages ranging from 12 to 2, roughly?
13 to 4.
13 to 4. Okay. They grow up fast.
They do.
So Mr. Gutierrez, as far as the new place you're in there in Vancouver with your girlfriend, is there space for the children?
To be honest, it's a 2-bedroom apartment, which her daughter has 1 room. We have the other one. I mean, there's plenty. The living room area, it's plenty big. And that's about what I have for now. It's
right.
We were trying to move into a 3-bedroom apartment so that I could have an extra room, or we could have an extra room for bunk beds or something set up for my kids. But again, due to my circumstances, I'm not able to be able to pay my more, I guess, or help out more with bills and my part of the rent and stuff like that.
Okay, thanks. Ms. Long, do you have any thoughts related to space and the children? Any concerns?
I think that they'd be fine for, every other weekend, staying the night.
Okay.
I have met his girlfriend. She's met the kids before, and we're very cordial. So.
Okay. And then, Mr. Gutierrez, I'm just having, and maybe you can provide me some assistance on this. As far as your motion to modify the parenting plan, how long ago did you file that? How long has it been since you initially filed?
I believe it was in September, because
Yeah, it's been over.
The reason I did it then is because I didn't have nobody at the time. I was spending time in my car, and I was hoping would have a place of my own. Yeah, I was just struggling at the time, and that's what I was just searching for, something to just get on my feet.
Right.
income to get on my feet, basically.
Right. Okay. All right. I appreciate that clarification.
But at the time, child support, instead of maybe possibly being lower because my pay wasn't lowered at work, child support just got higher for me, and the struggle just became more of a struggle.
Sure. Yeah. Okay. All right. So at this point, it sounds like, the salient issue as far as Mr. Gutierrez, he's in compliance with his treatment. And Mr. Lawrence's suggestion is well taken to have Mr. Gutierrez provide monthly compliance reports as far as his treatment. So that means, Mr. Gutierrez, continue on what you're doing with your treatment, engage, be in compliance, and then we'll need a report filed each month supplied to Ms. Long and Mr. Lawrence, indicating that your treatment compliance, your treatment status, and hopefully it'll continue to be compliant. But that just needs to be done on a monthly basis. You can talk to your counselor, and they can help with that. As far as, yes, go ahead.
I was just gonna ask, the monthly report from my counselor. Is that something I need to do like on the last week of the month, the first week of the month, or is there a specific date?
Yeah, that's a great question. I appreciate the question. So for the month prior, it should be the week following that month that the report should go out.
So the last week.
So the first week of the next month. So for example, your compliance report in March, you'd have to have that out by April 5th, the first week of the next month, or the following month.
Oh, okay, got it.
Good. So as far as the motion to modify the parenting plan, at this point, this motion has been pending a long time, 6 months. And a lot has happened during those 6 months. Mr. Gutierrez is doing a lot better. He's still struggling financially, and it's tough out there. But he's doing better as far as like with the SUD, substance use disorder treatment and the like, and that seems to be controlled at this point. So I'm going to deny the motion to modify the parenting plan, and the parties will continue to follow the parenting plan issued on June of 2022. I recognize that there's a midweek provision, and if that's cost prohibitive, the parties have to kind of figure that out. But if it can happen, it should happen. It sounds like Mr. Gutierrez might be in a position where it's easier for him to do that since he's closer. And then the weekend visits, as noted in the parenting plan, will continue. I am going to add that one caveat of continuing compliance with SUD treatment, and then provide the compliance reports to Ms. Long. So that'll be the court's order. So I'm just putting a notation here that I'm denying the motion to modify the parenting plan. I'll do an order that keeps the June 3rd, 2022 parenting order in place, and the parties will follow that. So that'll at least that concludes the matters that were before the court. And I'll just ask if there's any questions or clarifications. Mr. Lawrence?
No questions, Your Honor.
Thank you. Ms. Long, any questions or comments?
No.
Mr. Gutierrez?
Just as far as like my financial circumstance, is the child support going to stay the same, or is it going to go back to the $1,240 there was on the June of 2022, I believe, parenting plan? I mean, like I said, when I turned in paperwork on September of 2023, I turned in some pay stubs as well, on regards of my pay being lowered.
Right. So there's the initial June 3rd, 2022 child support order, where it shows Ms. Long with a net income of $2,700, Mr. Gutierrez at $4,500, and that set a transfer payment of about $1,240. Does that sound right?
Yeah, that was the original one. That was the first one.
And then you filed your motion related to the child support back in September of 2023, where you indicate that there's an incident of domestic violence in January 23, and then the no contact order, and you got the drug evaluation done, and that you're asking for a 50-50 custody arrangement, spend time with the kids. And that's, looks like that was the basis of the motion or change request, is that you were asking for a 50-50 parenting plan, with us now going to just the June 2022 parenting plan with the weekends and the like. I don't know if there's a basis to modify that. So, Mr. Gutierrez?
I mean, what do I need to refile the paperwork? Do I need to update?
So you said back in June, or pardon me, September, that you were getting paid about $650 a check, or twice a month.
Well,
has that changed? Is that different?
I'm pretty much, that's pretty much what I'm getting, like, for me, after fees and taxes and child support and everything being taken out. Yes, that's still about the same.
Okay. So it looks like there was an updated support order in November of 2023 that moved it to $1,573 per month.
That was child support enforcement. They took over.
Yes, yes. So any issue related to child support would necessarily, we need to have child support enforcement present. They're unfortunately not here today. They were here earlier. And I can see why they may have thought that the case wasn't on for this particular issue, because it was 6 months ago that the petition was filed.
They already did their modification though.
Yeah, back on November 2023, correct?
Yes. So they already completed their part of this filing that he did.
Yeah.
That was them doing their modification, and they actually raised it.
Right. Yeah, it went up. Mr. Gutierrez, are you since you filed in September, have you changed jobs? Has your income changed? Your financial situation changed?
No, it's stayed about the same. Those, if I give you another, if I was to turn in another 2 pay stubs to the court, and they probably, the numbers will be just about the same or pretty close.
Okay. Okay. That's helpful. I appreciate everybody's input. So as far as that motion to modify the child support, I'm going to deny that motion, because there's been no significant or substantial change in the situation of Mr. Gutierrez, and especially since there's a denial of the modification of the parenting plan. So I'm going to deny that motion to modify the parenting plan. All of that will be included in an order that I'll get out to the parties before Friday afternoon. So that concludes the hearing. So just any final points of clarification?
All
right.
Go ahead.
I was gonna say that I will not be able to have my kids until the weekend of April 6th, because this weekend I will be leaving town to go visit my mom, and I'm not coming back until the following weekend. So
okay.
So
maybe what we could do, Mr. Gutierrez, that sounds like that'd be a good communication for you and Ms. Long to have about the kids. So allow you to have that offline. Other than that issue that you need to talk to Ms. Long about, any other issues that we need to address today?
No.
I guess not.
Right, Mr. Lawrence?
No.
Appreciate everybody's time and input. That'll conclude the hearing today. Thank you.
Thank you.
Thank you, Ron.